Okay, we're ready to go.
Okay, let's get started. So welcome everyone to the February 16th, 2021 meeting of the Alpine City Planning Commission. And we have with us in the City Hall, Troy Slade on Planning Commission. And then from Planning Commission joining remotely, we have John McKay, Ethan Allen, Ed Bush, and Alan McDonald, and myself, Jane Greiner. And then from the city, we have Austin Roy with us, who is the city planner, and he's at City Hall. And then Jed Muhlstein, the city engineer, and Hiram, who represents the legal team. Is that correct?
That's correct.
Hi, Hiram. Okay.
Hi, how are you doing?
Great. After we get started, during the public comment, just before that, it'd be great if you introduced yourself, okay? Let's go ahead and have the opening prayer by Troy Slade, and then the Pledge of Allegiance by Ethan Allen. So everyone can.
Our dear Father in heaven, we are thankful that we can be able to be in this beautiful community. We're very thankful for the moisture that we've been receiving, and we are thankful for the beauty which surrounds us and the wonderful people which surround us. We ask you to bless us this night, and as we serve in this capacity, that we can be able to do what is best for the citizens of this city and make the best decisions that we can be guided and directed. And we ask these blessings of thee, and we do so in the name of Jesus Christ. Amen.
I have to unmute, sorry. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Okay, thank you. I wanted to take a minute just at the beginning and have Hiram introduce himself. I'm not sure if the other planning commissioners were aware that our the legal counsel that we've had for several years, David Church, retired, and we have contracted with a new team. And so Hiram, would you take a minute and just introduce yourself and your team?
Yeah, I'd love to. So my name's Hiram Bosserman. I'm an attorney here in our offices are in Salt Lake City of the law firm of Bennett, Tuller, Johnson, and Deere. We started with the city back in December, or maybe a little bit before that. Might have been November at that time. But my partner with me we kind of take a team approach to the cities that we represent. The partner that I work primarily with his name is Craig Hall. He's been a municipal attorney for decades and decades, and so we work together to provide services to the city. I also have another member of our team by the name of Steve Doxey, and he also has been doing this for a very long time. And so together we kind of help run the city and the legal department of the city, and have enjoyed it thus far for the few months that we've been here. So if any of you ever have questions, and later I'm going to be presenting on open public meetings in this forum, and if you ever have any questions, feel free to reach out to myself or to Craig, and I'll provide our information at the end of my presentation. Everybody can write down our number. Feel free to reach out to us if you have any questions or concerns.
Thanks, Hiram. We're excited to have you here. David Church was here for a long time, and I think it's great that we have a team of people now that can give us, a lot of broad experience. So,
hey, Hiram, is the Deere in your firm Monty Deere?
Yes. Yep.
Yes, it is.
Monty Deere is, and I believe another resident of Alpine is Barry Johnson, if you know him as well, lives right next door to Monty Deere.
Monty, yeah.
Both of those are our founding partners in that name, Bennett, Tuller, Johnson, and Deere. Yep.
Oh, I didn't realize that Johnson was as well. That's great. Two very great members of our community. Those guys are great. I've got kids that have participated in sports and different things with them. They're awesome. So.
Yeah, they're great.
Okay, well, good. All right, well, we'll go ahead and move forward. So now the next portion of our meeting is public comment. So if anyone who is watching on YouTube has a comment on an item that is not on the agenda, you're welcome to type that into the chat in YouTube right now. And we'll give you a few minutes to do that because there's about a 30-second delay. While we do that, we'll ask Austin if he had any emails submitted, or if anyone else had any emails submitted to them that they asked to be during the public comment portion of our meeting. Again, reminder, it has to be on something that's not on the agenda.
All right, thanks, Jane. We have not actually received any emails before the meeting tonight, so.
Okay, great. Okay, did anyone on Planning Commission have anything they wanted to bring up at this time in the public comments? Okay. So if we don't see anybody who's messaged in chat yet, then we'll go ahead. Officially, people, if they're watching this later or on YouTube, should submit those comments by 5 o'clock via email, but we always like to give people a chance if they are spending the time to listen to us live or in the City Hall attending, a chance to also comment. So, okay, we'll go ahead and move on. So the next section we have is reports and presentations, and we have open public meetings training by the city attorney. So I don't know, Austin, if you were going to introduce that first or if Hiram's going to hop right in, but we'll turn it over to you guys.
Yeah, I think Hiram, you can just take it away.
Man, no matter how many times I do Zoom meetings, right? You always start talking before you hit mute. Apologize about that. Yeah, so I'm happy to be here, at least electronically with each of you, and hopefully in the future we'll get to meet in person and talk. But it's our favorite time of the year, right? Our open public's meeting requirement that we need to fulfill, and training just to refresh our memories on these type of issues and laws. Now, I was going to ask if Austin, if you don't mind pulling up that presentation. I don't think I have the capability, at least that I'm seeing here from my screen, to share my screen here in Zoom. So if you wouldn't mind pulling up that PowerPoint.
Sure, one moment here.
If you could pull us to the very first slide, appreciate it. Now, I promise I will try. I'm going to try to make this quick and painless, hopefully informative. I've got a little bit of a quiz for us to run too as well. Okay. So open and public meaning trading. Go to the next slide, Austin. Sunshine laws, and go to the next one. Does anybody know what sunshine laws are? Have you ever heard that term? Anybody here on the Planning Commission? Great, I see Jane nodding her head. Jane, can you give us a? I
could be wrong though, so I'm kind of hesitant to say, but I think
no, I think it's exactly what you're thinking. So.
But they're laws that make sure that nothing's done in secret. That the public is aware of what's going on.
Yeah, that's a good description. Yeah, sunshine laws, they're regulations. If you're speaking, they're either regulations or laws, right, requiring transparency and disclosures, particularly in government, right? They can apply in other places, but our focus, of course, is government and government bodies. If you can go to the next slide, Austin. So this first started, I'll just give a tiny bit of history. I don't want to spend a ton of time on this, but this first started in 1976, the Sunshine Act, or the Government in Sunshine Act, as it's specifically called. It requires the following: that every portion of every meeting of an agency must be open to the public observation. Now, this was the federal law. Utah obviously has adopted an analogous statute here. Basically, it's just that these procedures, there's procedures in place that ensure that the public is provided with adequate notice of the agency's meetings, agendas, and that there is also transparency in the decisions made by the governing bodies. The intent of the act here in Utah, and if anybody is curious, the code provision is Utah Code Section 52-4-102 is, or 101, in fact, is where it starts. With our sunshine laws here in Utah, the intent of the act, as the Utah legislature is may set forth there, says that public bodies, quote, exist to aid in the conduct of the people's business, end quote, and also says public bodies should, quote, take their actions openly and conduct their deliberations openly. So this is the purpose of these Sunshine Acts, is that everything done by a government body is done in the open, right? Public, I've heard it phrased this way, public business should be public business, essentially, right? And that's what we're trying to ensure, and that's why there is this requirement that we meet and talk about open public meetings and our disclosure requirements, our notice requirements, our recording and minute requirements, and all of those things. You can go to the next slide, Austin. Again, legislative intent in this, in the Federalist Papers, just another thing that the people are the only legitimate foundation of power, and it is from them that the constitutional charter is derived. Government is and should be the servant of the people, and it should be fully accountable to them for the actions which it supposedly takes on their behalf. So staying with the founders and the framers and moving into Utah law, they adopted these same principles. Government is by the people, and so we should be accountable to them. You can go to the next slide. I think this is just a picture, and we'll move beyond it. This is just President Ford signing the Sunshine Act. So before we hop into the quizzes, I'm going to just give you a basic foundation, and I'm sure most of you know all of these things. And again, I'll try to be brief so we don't fall asleep at this. But basically, there's just a few areas of law that these sunshine laws here and these Open and Public Meetings Act here in Utah actually deals with. The first one are meetings. So I'll put the before we hop into the quiz, definition of a meeting. Does anybody know? Now, again, we're not together, but if anybody wants to raise their hand or just pipe in, can you give me what you understand is a meeting under the Open and Public Meetings Act here in Utah? Does anybody know what constitutes a meeting?
I'm going to guess that it's when more than two people discuss something that's of city business.
I hope everybody takes that approach, because I think that's the safest approach. But really, actually, under the Public Meeting Act is it's actually when there's a quorum present. That's what constitutes a meeting under the Open and Public Meetings Act here in Utah. When there is a quorum of a body, a decision-making body, they need that constitutes a meeting that has to have notice 24 hours, at least 24 hours in advance, and has to meet all the other requirements that we're going to talk about here. But best practice is exactly what Jane talked about. It's best practice is to not meet with other members if we can. And of course, I know from my experience and Craig's experience and all of our experience at the law firm that, of course, council members, planning commission members do a talk outside of planning commission about certain situations. And the best practice definitely is to keep those discussions, if we can, to an open meeting itself. Now, the definition of a quorum is just a simple majority, just so we know that. So how many members are there on the planning commission? Is there 7? Is that correct? 7. So a quorum would simply be when 4 of the commission members are together at any time talking about anything related to the city. That would constitute a meeting. Now, as I mentioned before, you need 24-hour notice of the meeting, including an agenda, the date, the location, and the time of the meeting. All those have to be on the notice. The notice has to be posted at the principal office, so City Hall in this case, and also on the government's website, which is the Utah Public Notice website. Also, there should be a schedule of regularly scheduled meetings that should be posted and noticed once a year in advance. And I know that this city does a great job of that. I've looked at that and important that they post it in advance when planning commission meetings will take place. And then there needs to be an agenda, and the agenda has to, the quote is, it has to reasonably specify when, or the items of topics for discussion or action. Items raised by the public but not on the agenda may be discussed, but no action can be taken, right? If somebody comes before the planning commission and says, hey, I submitted a conditional use permit to you last week. I want to know the status of it, and I want to know what this planning commission thinks about that conditional use permit application. If it isn't on the agenda and it's not noticed, although it was raised in public comment, this planning commission can discuss it, but it cannot take any action on that item because it wasn't noticed beforehand that an action would be taken on that conditional use permit. That makes sense. And before I lose anybody else from sleeping, again, there's written minutes requirements. We'll talk more about these closed meetings. Craig and I were talking on the phone today, and I just can't imagine a circumstance. There might be, but I just can't imagine a circumstance that the planning commission would need to have a closed meeting. Generally, that's reserved for the mayor and council, city council themselves. But we might be able to conceptualize a circumstance, and maybe we'll try to come up with some circumstance where a closed meeting might be appropriate for a planning commission. Okay, let's hop into quizzes, since everybody I'm sure here is familiar with open public meetings. Can we go to the first one? Excuse me. And Ethan Allen, would you mind reading question number 1? I know this is going to take us back to high school and how I'm doing it here, but.
Sure. 5 members of the 7-person planning commission inadvertently meet at a local restaurant. They sit down together and discuss the upcoming planning commission meeting. Serious discussion occurs between all 5 members regarding a zoning decision to be made at the next meeting. Concerns?
All right, Ethan, what do you think? Are there any
Well,
concerns
so it's a de facto planning commission meeting taking place at the restaurant. So
that's right.
So that would be one that did not have notice and did not have adequate opportunity for the public to be there.
That's right. Yeah, the concerns are right. This is a governing body. It's a quorum, and it's a meeting under the act because there's more than a simple majority. And so this is you're correct. It's a de facto meeting, and it had to have notice before a discussion could take place. And so it would be in violation of the Open Public Meetings Act.
Hiram,
Yeah.
I have a quick question on that one. One thing that came up to me before is when we are all on an email chain and we email regarding something that's on the agenda and people are sharing their opinions and it may go back and forth and everyone is on that email. What is the view on that?
That's great. Let's go to question number 2 because this is exactly this scenario that you just brought up. Can you read that, Jane, for us?
Sure. 4 members of a planning commission have a text message group where they regularly share funny memes with each other. A few days before an upcoming meeting, one of the members of the group asked a question about a conditional use application to be discussed at the next meeting. Concerns? ?
So I'll answer, since you answered this question, this goes right in line with what you're talking about.
Mm-hmm.
Our opinion is yes, and I believe the law would support that, is yes, that is, if you have a text group or an email chain where all commission members are on it, or a quorum of commission members are part of that correspondence, and there is talk about what's coming up at the meeting or a zoning decision or whatever it might be, that is a meeting.
Mm-hmm.
And that should not occur without proper notice beforehand.
Okay. So what if after a meeting, one of us shares, just replies to the group and say, hey, I just want to let you know, this is why I voted this way. These are my thoughts on this, blah, 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 because we often do things like that. And I've been told that's okay, but just kind of curious, because otherwise then we couldn't have any follow-up with the city and people like that until we met again.
Yes. So certainly, again, you're more than welcome to So there's some gray area here where I'm going to talk to you about best practices versus is it totally illegal?
Yeah.
Anytime you have a quorum, you're getting very close to that line, right? If you're in that. So you certainly can email each other separately, or a group of 3 of you, right? Could be on an email chain. If you wanted to reach out and say, Alan, this is, I appreciated your comments last night. I feel the same way you did. I hope we can push this on further. That's fine. You can have those conversations. It's when you get a group of you and you start discussing matters that it starts to become a meeting under the law. And so best practices, yes, you might be, it's kind of a fuzzy line there, whether you can do that or not. Best practice would be to keep it less than a quorum if you're going to do that.
Okay.
And always remember, and something we'll talk about in just a second, is if all of your communications are subject to a grammar request, right? Now, so what that means is if you do have discussions via email behind closed doors, somebody could come along if they disliked your decision and try to get a grammar request, and they would be able, in many circumstances, to obtain all those email correspondence. So sometimes as best practice, as well as if it's just between one and another council member, is to just pick up the phone, talk to them that way. But certainly when we have 4 members of the Planning Commission on a thread together, we're getting very close. And we recommend that that does not take place between.
Thank you.
Great. We'll go to anybody else have any questions on this? So text message.
Hey, Hiram, I have a quick question.
Yeah.
What if the communication between 4 or more members have to do with process versus substance, or procedure versus substance? And I'll just give you for example.
Okay.
Let's just say there's a text or an email that goes around, which is something like, hey, I noticed we have a particular item on the agenda. I didn't have a chance to see the city council's take on that last meeting. I wasn't there and didn't watch it on Zoom. Did city council discuss and what was, in other words, kind of a procedural, just, hey, did they tee something up for us, or was there anything in the city council discussion that I missed that I should know for our meeting tonight or tomorrow? Something along those lines.
Yeah, so I'll take you back to the language of the statute. They say the convening of a public body with a quorum present is, quote, for the purpose of discussing, receiving comments from the public about, or acting upon a matter over which the public body has jurisdiction or advisory power. That's the definition of a meeting. So in this circumstance, yeah, certainly there's going to be procedural questions. If you send out an email saying, hey, I heard Planning Commission meeting got moved to 6 o'clock. Is that correct? Right. We're not going to be getting into any dicey situation there by sending out an email to all the commission members or saying, hey, I heard that the city council was sending this ordinance back. Do we know if they did that or not before getting into? That's going to be fine. It's when we start to get into discussions about the actual substance of what is going to occur at the public meeting. Did that answer your question, Alan? Great. So yeah, obviously, and obviously, this question is meant to show that, if you have a group message where all you talk about is the trails. I know people in Alpine, just from my limited experience, they love their trails, love their mountain biking, love their running trails. There's a group message, group email chain where all you talk about is running, or biking on these trails. That's completely fine. It's when the discussion, actually subject matter, turns into anything city related, anything of substance that's going to be discussed or potentially discussed at an upcoming meeting, then we're getting into meeting territory that needs to be noticed. All right, Austin, can you go to the next question? right, let's get a new volunteer. Let me go down. About John McKay. Do you mind reading this, John?
Planning Commission member Z cannot attend the next commission meeting in person. He will be in some exotic place like Waco. Can he attend the meeting in alternate manner?
What do you say, John?
Well, evidently we can, but is it because we're on a special exemption with electronic meetings, or could we otherwise do it anyway? I don't know.
Yeah, so you raise a good point. Now, obviously, we all feel like this is normal during COVID, but let's take COVID out of the mix. You guys believe that you could join electronically to a planning commission meeting if you weren't there in City Hall to participate? Pre-COVID or hopefully post-COVID at some point, right? Yes, that's right.
So I've been at city council meetings when a member was there via phone. So I
Yes,
think
that's
that you can.
Yes, it is. It's absolutely allowed for it to be there. There needs to be an anchor location. And if we're talking best practice, Craig and I always recommend, if possible, and obviously this is setting COVID aside, but if possible, try to have a quorum in person at City Hall. And the purpose of that is for if the public comes before the body, before the planning commission with their public comments or in a hearing or whatever it might be, it's best practice to have them at least before a quorum in person. But as long as there's an anchor location, yes, you can call in or Zoom in if you can't attend. Now, there was a special exception passed recently by the legislature when this pandemic broke out, and that allowed the city to, by a signed declaration by the mayor, to suspend an anchor location due to COVID protocols. So
And we did the same
long
with
as-
Planning Commission.
yes,
I signed something, we set that up, which is why I'm not in City Hall right now.
that's right. Yeah. So currently, as it stands, we're allowed to do that during this pandemic, and I imagine if there's any other health concerns that come up in the future, using that same provision, we'll be able to.
And I think, do we have to renew that every 4 weeks, or how long does that last? I believe a
Yeah,
month.
I believe it's every 30 days. Yeah, I believe it's a month.
Mhm.
So that should be renewed, and just with the date change, and we'll have you sign that again as long as this pandemic continues. So great. Let's go to question number 4, Austin. Oh, so yeah, here are the requirements. Remember, affidavit for a complete virtual meeting. We just talked about that there has to be a signed affidavit to have no anchor location. Also on the notice, we better indicate how the public can access our meetings through Zoom or go to meeting or whatever. Okay, we'll go to question number 4 now. I'm gonna pick on somebody else. Ed Bush, would you mind reading number 4 for us?
Sure. City Hall has burned down. The council and the mayor want to hold a council meeting right now. Can they do it? I would imagine under such emergency types of things such as this or natural disasters that the mayor and the council can meet in an emergency session.
That's right. You're correct. What is required under the statute is the best possible notice that can be given in these emergency circumstances. Now, again, Planning Commission, I tried to think of a circumstance where the Planning Commission would have to have an emergency meeting. I don't know. Maybe one of you can come up with a scenario. I don't see it where that would happen. But just so you know, if there was an emergency that required, if the mayor's saying we have to have something immediately, there's this or that. Sorry, it's hard to conceptualize where the Planning Commission this would be, but just for your own knowledge, yes, under an emergency situation, as long as the city council mayor provides the best notice possible that they can of the meeting, they can.
We actually, I recall actually having one where through maybe a mistake or something that we weren't able to get something done. And we needed to have it done to be respectful to the people involved. And so we had an additional meeting right before city council meeting. And that was called and we met to handle the item of business that needed to be done so that it could move forward. So probably something along those lines would be about the only time we would need an extra session.
And almost always, it's a good point, Jane. There could be situations where this comes up for the planning commission, but almost always in those circumstances, if there's a mistake made or planning commission approval needs to happen before the city council, almost always we can get out a 24 hours notice for the planning commission to meet, right? So say city council meetings Tuesday, we need the planning commission to meet Monday. Let's notice it up on Sunday, put notice out there, right? On our website, on the government website, and we can hold the meeting and it's not an emergency meeting, right?
Right, that's true. So it's 24 hours is all that's required.
That's right, only 24 hours notice. So,
okay.
So in most circumstances, we can meet that.
Yeah, absolutely.
Somewhat of an emergency, but not really an emergency, like Paul just burned to the ground, right?
Right.
So that's a good point. Okay, let's go to question number 5. And click it one more time, will you, Austin, for me? And let's see, I see Jed Muhlstein. I'm here, would you mind reading that, Jed?
You bet. Question 5. Electrical devices are wonderful tools. During a council meeting, the following occurred. A citizen in the audience doesn't want to speak publicly about an issue because his neighbors are in the audience. However, he sent a text message to Commission Member A with his concerns.
All right, there might be some confusion there. It says council meeting. Let's say, just ignore it, say it's a commission meeting, right? So in this scenario, we've got a citizen texting a commission member during the meeting, expressing concerns with it. What, if you can click one more time, Austin, I think, does anybody believe that this is an issue here?
I think it's a problem, but I don't know why you want to say it, but it's, I have seen it happen where they're basically participating in a meeting when it's not a public hearing. They are voicing their opinion and wanting it brought forward.
Yeah, so there is no, I'm glad your antennas are sticking up. There is no actual law that would prohibit this, but we're talking best practices. Since we're trying to follow the spirit of the law here, if somebody is texting, you and the council member finds it persuasive and doesn't want to, and just, either relies upon that without informing anybody, it seems like it's not open, right? Doesn't feel open. So best practice, I think, would be to, if you got the text, if you wanted to keep the name anonymous from who you got it from, you can say, hey, I got a text message during the meeting. You would say, I just received a text message from an individual. Or if you got the message beforehand, oftentimes as commission members, you'll receive emails from citizens, right, that are concerned over an issue. And you can say, I've received an email from a specific person. I'm going to keep their name anonymous unless they want to come forward. But they've raised this issue or that issue. That way it's open and it's before the entire commission for them to consider. That's best practice. All right, I'll read question number 2. Commission member X sends an email to commission member Z during the commission meeting expressing extreme disappointment in the position X has taken. Does this feel like an issue? Yeah.
Yes.
Yeah, again, it's not, I don't see anything in the law itself that might say that is absolutely illegal to do. But going along with the spirit of the law, side conversations during the middle of a commission meeting about, I can't believe she's saying this or that, or he's doing this or that, right? a comment box. Those things need to be, that discussion needs to be out, open. If somebody has a problem with a position another's taken, we need it on the record, right? And that will allow us to be transparent in our decision making. And all of this is really geared to make the citizen feel like everything was open and fair and honest dealing with government and a public body like this.
And
All right,
can I
let's
add-
go.
I'm sorry, I
Yes,
was just
go
going to add, it also kind of protects you and helps you feel more comfortable. I have had people, essentially trying to coach me on what they want me to say in meetings by texting me during meetings. And it's good if you can just say, that, any communication needs to be public or things like that. It gets you out of some awkward situations.
That's right.
Just say no.
That's right. And that's a great point. I think just having everything open and transparent will keep you, a lot of times I've seen in my experience, and we hear complaints about this all the time in the cities we represent, where somebody will say, well, I had a conversation with, commission member X, or I had a conversation with commission member Y, and they said that, I could do this, or this would be completely fine. And and those type of conversations do get you in trouble. It's better to have those discussions out in the open in front of everybody. All right, let's go to the next question. All right, let's see. Who haven't I picked on here? I don't know who M Fox is.
Marla.
Marla.
She's recording.
Hi, Hiram.
Hi. Wait, do you want to read this, Marla? For
Sure.
us? Number 3.
Number 3, over 400 emails have been sent only to a single commission member regarding an issue. Are these emails public record? Yes, I think they are.
You're correct. These emails are public record. So, and they're subject to a grammar request. So this is one thing I'll make mention, talking about best practices and talking about having email correspondence back and forth with citizens or between commission members, council members, Austin, Shane, whoever it might be, right? A lot of these are subject to a grammar request and are considered public records under these same laws. So I'm going to give you best practices. Something that we advise our city members regularly, and this might not be practical and you don't need to follow it if it's too big of a chore, but you do need to keep in mind that if you're using a personal email account for your planning commission business and to conduct your planning commission business, somebody can seek a grammar request of your personal emails. Now, certainly we as your legal team and you will try to filter through what is personal and what's not personal, but you can get in a dispute with somebody over when they think you have more and you're like, I don't have any more, right? They can seek legal avenues to try to get more of your communications out. So sometimes best practices, and again, planning commission, it might not, if you're only meeting every other week and you really don't talk about it that much, might not be a big deal. If you have if you were a different political position, maybe that where you got emails all the time, maybe if you're the mayor or something like that, where you're constantly getting emails from citizens, it might be best practice to have your own set aside email for planning commission, right? Either a government issued email address for the planning commission, so that it's very easy if there's a grammar request, that's where all my communications with the planning commission are located, and I don't have to filter through personal emails and get in a dispute on what's personal and what's not personal when a grammar request comes along.
Hiram, this is Ed Bush.
Yeah.
I've noticed in Alpine that, like, for example, the city council and the mayor are given email addresses that are part of the Alpine, city server, so to speak, but planning commission does not. Would you recommend the city actually set up accounts for the planning commission also, just for that reason?
Yeah, now, so this is kind of where it comes into the practicality of it, right? If you're on the planning commission, you might not be getting as many emails from the mayor, right? The mayor certainly is probably fielding a lot of emails from concerned citizens over whatever the matter is, and over contract disputes, right? Or entering this or that landscaping, people here or there, whatever it might be. I'm going to leave that up to Austin, but it's definitely a good practice to have one. And so it's something maybe we can talk with Austin and Shane and whether they think it's a good idea to also give this political body their own email address that they can use from the city. But because I imagine with Planning Commission, and again, I'm new to this here in the Planning Commission, maybe Planning Commission is here in this city is really, everybody's really into it. And you field a lot, and maybe I'll ask that as the opening question. Do you field a lot of communications with citizens before Planning Commission meetings?
It depends. It depends on what's up on the agenda. There have been
Okay.
occasions, and I have actually had to turn over emails before,
Okay.
a few years ago. But it's very rare that I get emailed by a citizen. I don't know about the rest of you.
Yeah, so it's I guess it's a matter of practicality. Best practice would be to have a separate email. And so it's something if Austin and Shane, if it's
Mhm.
practicable and it's easy to do, maybe we can have it done.
Yeah.
If it's not, then if we're not fielding a lot of communications, we can use personal emails. There is that
Yeah.
potential for them to try to come after some of your
Right.
personal emails.
Well, we'll follow up on that.
Hey, Hiram,
Yes.
this is Troy Slade.
Okay.
So do we do anything with these emails that we receive, or do we just leave them in our box?
Yeah, that's a good question. Yeah, you should not, any communications you're receiving related to Planning Commission and that kind of stuff, you should not be deleting those. And there should actually be, and we can discuss proper kind of storage requirements for these emails. Depends on how, and I haven't looked at this city's recording ordinances specifically, because generally each area of communications or each area of documents, there's a time limitation set on them for how long a city has to store those. There's an act that governs that, but the act also allows ordinances to be passed individually by the cities themselves to say zoning issues we're going to hold on to for X, right? Communications or documents related to, like, for example, city council meeting minutes, Planning Commission meeting minutes have to be stored definitely, right? And so there's different times. But in your practice with your own personal emails right now, yeah, don't be deleting them. I can get with Austin and Shane, or we can get each of your individual emails and send out an email from Craig and I telling you exactly how long we need to retain these emails when we have emails from citizens or emails between council or commission members or council members from the commission. Does that make sense? So yes, don't be deleting it. If somebody sends it to you, don't just delete that. I'm not going to look at that because technically that's a public record that somebody has created. Does that make sense?
Yeah, thank you.
Yep. So yeah, that's another reason why it might be best practice to have a separate email in these circumstances. All right, we'll go to the next slide, Austin. Oh, it looks like I repeated the number. I'm sorry, it should be question number 6. Any last volunteer? I believe this is our last question. Last example. Any volunteer that would, I don't know if
I can read it. I haven't read one.
Oh, great. Thanks.
Okay, question 5. 3 of the commission members are attending a commission meeting virtually through Zoom, as are the public. There is a problem with the audio and no one can speak electronically or be heard. Concerns?
What do you think? Are we concerned about this at all? This happens all the time. I mean, I've been in several council meetings. This happened to us in just a neighboring city that we represent 2 weeks ago on a council meeting where there were some council members present, some attending virtually. Public was attending virtually. audio wasn't working. Are we concerned?
Yes.
Yep.
Yeah, we are. Again, what we did in the neighboring city and best practices here is if Zoom isn't working, or if other commission members can't speak via Zoom, or they can't hear via Zoom, and we can't get it worked out, best practice would say, hey, we are going to suspend tonight's meeting. We're going to move to continue it, and we're going to notice it up in a day or two when we have whatever electronic issues worked out. And that really is to protect the governing body, so you get a full discussion of all commission members that want to participate. But it's also really important for the public, right? If they can't voice their concerns during public comment, or if it's a public hearing or whatever it might be, if they can't, or if, for example, say an application is before the planning commission, if the person that made the application can't talk on behalf of their application, I mean, those are really, really big problems. And the best thing that we should do is just say, hey, we're having technical issues. We're going to have to reconvene, and we'll notice it up for 2 days from now, and we'll do another planning commission meeting. And it can be that quick. So, all right, let's go to the next slide, Austin. I think this is kind of just the wrap up. If you can click them all, we'll click it all the way down. I'll just do a recap really quick. So we've talked about what constitutes a meeting, right? A quorum together talking about city-related matters. Electronic meetings are fine as long as we have an anchor location, or if we have a declaration that's suspended an anchor location. We talked about different precautions that we could take, right? In terms of the emails that we use, in terms of talking with each other before the meeting. Notice requirements, 24 hours is the requirement, posted at the primary location, posted online. Closed meetings, again, likely not to come up, but has anybody here on the commission participated in a closed meeting? Don't tell me what happened in the closed meeting. I just want to know generally if anybody has participated in a closed meeting. No. So I can't. Planning commission, I'll be very brief here. Closed meetings are meant, there's basically a number of criteria, and I'll just list them briefly. These are issues related to personnel, like a characteristic of an employee or misconduct of an employee. That would be a category to discuss. Not going to come up before the planning commission, likely. If the city is planning on selling a piece of property, that also is a topic. Selling or acquiring real property is a topic, and that's likely going to be before the city council, not planning commission. There's also, anytime there's imminent litigation pending, that also, if we need to discuss something related to litigation matters, either litigation that's pending or we think we're about to be sued as a city, that we can go into closed session for that. Maybe there's a circumstance where that might apply to the planning commission, possibly if there was some sort of really hotly contested site plan that was being approved, right? Or, something like that. Another one is if there's a security issue at all, security use of security equipment and things like that, or if there's any criminal conduct that we're going to discuss. And so most of those won't fall within the planning commission, but just so you know, closed meetings has to be done by a vote. Somebody moves to go into a closed meeting, somebody seconds it, and then there needs to be a roll call to enter that closed meeting. It can't just be a vote. There needs to actually be a roll call, but each member does votes to go into a closed session, and the person making the motion has to state the category for the closed session. So I move to go into closed session to discuss personnel issues and or misconduct, right? There's your category. And then I move to go into closed session to discuss imminent or pending litigation. That's how you would make the motion, and it would be seconded, and there'd be a roll call vote. Once the session is closed, then the recorder would stop the recording and restart the recording, because closed session recordings, they're always recorded, but they can only be obtained through essentially a court order. So if somebody pushed all the way through and asked the judge to review this closed session, we want to make sure that the recording's broken up. So that's just for whoever's recording the meeting to know that you would stop the planning commission meeting and then start a new recording for the closed session, and then stop it at the end of the closed session and go forward from there. Let's see. Any actions resulting from a closed session must be voted on in an open session, just so we know that, right? So if, for example, we wanted to discuss imminent litigation, like, I don't know, again, this probably wouldn't come before the planning commission, but a settlement agreement with somebody, or, for example, the commission is going to remove an individual for misconduct, they would come out of the closed session and then they would vote, I move that we discharge X for reasons disclosed in the closed session. And then there would be a motion or a second on that and a vote on that. Okay, the items in closed session are meant to be confidential and not to be discussed in the meeting itself. So there's closed meetings. Again, probably not going to come up very much here in Planning Commission. We talked about minute. I don't know if we talked specifically about minute requirements, but I can. This is more for our recorder. And does Bonnie run the recording of the Planning Commission meeting?
Marla.
Well, say that. Oh, Marla does. Okay. Okay, so she knows all this, right?
Yeah.
But in the minutes, you're going to include the descriptions of the matter discussed, names of individuals speaking, individual votes by name, if it's not unanimous, any additional information requested by a member. The meeting requirements, I talked a little bit about closed minutes, but just so everybody's aware, minutes must be approved within a reasonable time frame is what the statute says. And they have to be available. So the written minutes have to be available to a public within 3 days after they have been approved by this planning commission. Audio recordings must be made available to the public within 3 business days after the commission meeting. Okay. And hold on to any documents or trainings that were given, any documents used for trainings or anything like that. Those should be saved, and then we all know that we should have a document storage plan. And if there's any questions on that, I'm happy to get into specifics with that. Finally, consequences for non-compliance. Does anybody know if the planning commission fails to notice up a meeting and decides on a conditional use application, what are the consequences? Does anybody have an idea?
We get locked in Austin's basement.
That's correct. Aside from getting a nasty phone call, from myself or Craig. No, I'm just kidding. The consequences.
I would say that you'd have to redo the meeting, right?
Yeah, that's a good point. Yes, that is the solution, and we'll address that in just 1 second. The consequences for failing to is the statute makes clear that an item is voidable. Doesn't mean necessarily that it's void or null from the get-go, but say, for example, that the commission passes a conditional use permit, they authorize it, and it wasn't noticed properly. That action could be voidable, meaning that somebody could come along and challenge that action and void this planning commission's decision on that matter. Now, that brings us to a great point that Ed just talked about, which is what happens if we make a mistake, right? That's the last thing that I'll leave the planning commission with this. If an error is made in, say, posting or rescheduling or posting notice, or we didn't think we noticed up the correct agenda item and we had a discussion and an action item on an item that was never listed in our agenda, we can simply reschedule the meeting, right? And then take action again at that point. Say, for example, we decided to take action on some sort of site plan that we approved. It wasn't properly noticed. Just notice it up for our next meeting again, discuss it again briefly, and take a vote at that point, now that it's properly noticed and the public's aware of it. And that's how we can fix our mistakes if there are any. If you've noticed that there's an item that was supposed to be on the agenda that wasn't on the agenda, if it's an action item, we can't take it, but we can discuss it and then say, we're going to set it for next planning commission meeting for us to make the actual decision. Yeah, again, if there's an error made in an agenda action item, just re-vote on it in your next meeting with proper notice. With most situations, just do it over again correctly, but let's not make it a frequent practice, because if there's a frequent practice where this is happening, someone's going to raise concerns that, you know, we aren't following these laws and that we're actually just meeting in secret and deciding these without giving anybody proper notice. So,
Hiram,
yes.
One thing I wanted to verify with you and point out is, if we do have a planning commission where people have problems and last minute can't come and we don't have a quorum,
yes,
still go ahead with the meeting and discuss everything, but we just can't take any action on the items, correct?
Yeah, the best, yeah, certainly you can't. The best practice would be, if you don't have a quorum, I would say reconvene the meeting.
Okay.
If you want to get together and discuss about it without a quorum, you can, but I think if you're not going to have a quorum, I think the best practice would be to just say, hey, no quorum, we're going to reconvene. That's not very hard. Just put out notice again, right? Planning commission meeting is, you know,
Okay.
we're going to reconvene planning commission meeting in 2 days next week, or we're just going to miss it this time.
Absolutely. Okay. All right. That's what I want to know.
Okay. Any other questions? All right. Well, that is my presentation. You survived another open and public meeting session. Any questions? Here's Craig Hall, my name, our telephone number. I can get you our cards as well. And Austin or Shane, they have our information. Feel free to reach out to us if there's any questions about this or anything pops up.
Is this a yearly requirement that we have training on this each year?
Yes.
Okay. Thank you.
Yep. Okay. Well, that's it for me. So.
Okay. Thank you.
It's nice to meet you all, and thanks for your participation. Appreciate it.
It was very helpful.
Thank you.
Okay, so we'll just go ahead and move to the next portion of our meeting, which is our action item, which is ordinance 2021-6, accessory building setbacks, exception criteria. This has been back and forth a few times, and we've made some great progress with it. So if Austin wants to introduce where we are at this point in time, then we can move forward with that.
All right, thank you, Jane. So last time we met, this item, of course, was tabled, and we decided to table that for a couple things. So in Alan's motion, notably to consider appropriate language for movable buildings that can be moved within 24 hours or a fine, and also to look at the legal ramifications of encroaching on a city easement and the process for a resident to sign, to get a sign off from the city and utility company. So we've looked at this stuff. We've talked with Hiram and Craig and kind of run this language by them, and we reviewed it. So let me go ahead and just pull up the current language that we're looking at. Okay, here we go. Let's see if we can get it all on one screen. Okay, and then I'm going to zoom in here. Okay, so this is kind of the language that we've been drafting. So you'll see some changes since the last time we met. notably here, so let's see, the big one we changed was in item 5 or V. In the green there, it says so I guess I'll just read the whole thing. So the building will not be placed on land designated as a recorded easement, such as a utility or trail easement, unless the owners of said easement agrees to allow the encroachment. Documentation of the agreement shall be provided to the city. So we discussed this with Hiram and Craig, and it is within our ability to do this. In fact, they're going to draft us a kind of a template document that we could use in situations such as this, where someone would want to put something in an easement, encroach into an easement, and they would just have to get a sign off from, whether that would be Rocky Mountain Power or Dominion Energy Gas, or whoever it is, whoever is inside that easement would have to potentially give a sign off for that.
And then Austin, I don't remember if it was in city council or planning commission where it was discussed that is actually a fairly common practice, and that we already have forms. We were going to brush up on them, but we've done that.
So for the building department, they do, as part of the building application for a site plan, if the building is going to be, has to near an easement and there's going to be an encroachment, we typically will require that. So for example, like Alpine Fitness, there was a gas line that used to go through there. They had to get a sign off. Actually, that one, in that situation, the gas line was vacated, but similar concept there, that yes, we do have a sheet where on developments, that's typically what we do. For sheds and things like that, that's not something we've done in the past.
Okay.
But probably best practice moving forward is something that could be done, especially if we're going to allow structures inside an easement.
Okay.
Jane, where that form's been used is for a swimming pool.
Oh,
It
yes.
does not have any height. It's in the ground, so no neighbor's going to see it. Sometimes they have come in and asked if they could have it a little bit closer than 10 feet, and that's when they've had to use that form to go check
Okay.
utilities.
I just can't remember
Yeah, it hasn't been used really
in
for
this
sheds.
situation before. Okay, thank you.
Okay. Yeah, so that's item 5. Again, revised language since the last time you looked at it. So item 6, there was some confusion as to whether or not, that has to be 12 feet 6 inches. Of course, we had Councilman Thielen in our last meeting, and he was the person who made the motion, and it was of his opinion that his motion was to say that we should have a 12 6 inch height. It should be part of the proposed amendment to the ordinance. I did speak with some of the other council members who voted to approve that motion. Their understanding was a little more flexible. They said, well, when I voted to approve that motion, I was of the understanding that they would discuss the height and, see if 12 feet 6 inches was good, but maybe there's a better number. So that was kind of some of their of the other members' understandings of that. So, but we just left it 12 feet 6 inches. That's what was the motion, and so that's what we're using here in the language. Item 7, the building does not require permanent attachment to the ground and can be moved or relocated within 24 hours. So that, again, Craig kind of took a look at this. He felt like that was fine to describe a movable building or movable structure. If it can't be moved, and the 24-hour time period, we did discuss that in the last meeting, and you can argue it one way or the other, but it seemed like a reasonable time frame, especially if there's an emergency or something and we need access to an easement. Item 8, the owner acknowledges that they bear all cost of moving a building, including damage to the property, in the event an easement needs to be accessed, and fines shall be issued for buildings that cannot be moved within 24 hours. So again, we ran this by legal, and we do have the power to, find someone or make it so that they would bear the cost or responsibility of moving a structure, or, for example, if we had to dig up their sports court or whatever the case, if something's built in an easement, I'm just trying to give examples here, but we do have the power to say, especially if we put this in our ordinance, that they would bear the cost of having to replace those things.
Austin, on that one, what was the discussion? Because I know we discussed in the city council meeting 24 hours or not 24 hours, but what was the conclusion if the person, say, was out of town, there was some kind of a utility emergency, and so they couldn't be notified? Did we need to include language that the city could move the building, or it would, anyway? You recall that discussion?
Yeah, I do recall. So
Just throwing that out there.
yeah, that's a good point.
Back to it.
I mean, I know that, we've done that with other things, for example, like weeds. So, if a property's overgrown with weeds,
Right.
we'll send them a notification. We'll give them several notices. If they still don't do it, we'll contract someone to go out there and cut it all down, and then we send them a bill.
Yeah.
So similarly, in a situation where they're allowed to build in an easement, they don't, we have an access right to that easement. And so, again, they could be billed in that situation.
Yeah. So I just don't know if that language needs to go in there. So I think it probably should. That.
Hiram, do you have any
Something to do
comment
with
on
that.
that? Do you feel like we need to rethink that language with regard to what Jane's saying?
Yeah, it might be it's a decent suggestion. I mean, I think the planning commission can choose one way or another, but yeah, the biggest thing here in talking with Austin too about some of these fine line distinctions here. I mean, I imagine Austin might talk specifically about this maybe in a little bit, is talking about sports court cement pads on top of these easements. That's one thing I've been concerned about, and how we draw the distinction there. But yeah, I think we can relook at that language specifically.
Okay,
Did I
thanks,
answer your
Hiram.
question, Austin? I'm sorry.
No, yeah, thank you.
No, yeah.
Okay, so yeah, I mean, if that is a concern, it sounds like there's definitely some additional language that we could add in there.
Okay.
Okay, so item 9, the building will not exceed 200 square feet in size. This number we arrived at just because, that's common practice in a lot of other cities. Also, the building code dictates that a structure has to have a building permit when it's over 200 square feet in size. So, it's a number that's used in practice elsewhere. So it makes sense to reference something else out there. Item 10, the building will have no associated electrical, gas, plumbing, or mechanical equipment attached or running to it. And we relooked at this, and really we just don't see any way, staff, it's kind of our opinion that by implementing any of those things into a building, you're really making it how should I say that? It really is no longer a movable structure. So let me go back here. I think that I didn't get all of the language in here. So
There was something below that you skipped, Austin.
is there something I skipped? Okay, let me
Yeah,
see.
there's something at the very bottom you missed. That may be permitted if it's the solar power light.
Yeah, that's the one I was looking for. So I think what I was showing on the screen, can you hear me?
Yes.
Okay.
That's right there, the ending of that,
There we go.
the last sentence you missed.
Okay, yes, okay. So yeah, a solar powered light may be permitted if it does not prohibit the building from being movable as described above. So I believe it was John in our last meeting that kind of brought this up, and, great point. There's more and more we're seeing, kind of solar powered. I mean, they even have like security cameras that are solar powered that don't need an electrical, typical electrical connection. They have floodlights that do that. And so are those, as long as those things aren't running a line and they're not prohibiting the movability of the structure, they shouldn't be a problem. So that language there is to try and address that. And so, yeah, this is kind of the language that we put together. Again, we do, all of this is within our power as a city to enforce these things if we see it fit to add that to our ordinance.
Hey, Austin, this is Ed. I'd like to make a general comment on these additions and then a kind of a general comment on the whole thing here. But I did point out to you and Jed, I was not at the last meeting, but the language here it seems like we're putting two cases together and combining them. So we used to have one case where somebody wanted to build within the 10 and 15 foot area, but didn't have an easement problem. And then we had the issue of people who want to build within the 10 to 15 feet area that do have an easement to do that. But what this implies here is that if I look at item 7, it says the building does not require permanent attachment to the ground, can be moved or relocated within 24 hours. This ordinance would apply that to the case where there's no easement problem at all. Why would we want to do that?
Why would we want to do that? Well, I mean, what this ordinance is for people that want to build inside the setback area.
Right. So what you're writing is an ordinance that says everybody who wants to build within the setback area, whether there's an easement or not, has to have a movable building.
Yeah, that's the proposal right now. So, that's up for discussion. If you feel like that's too stringent on someone that wants to build inside the setback, again, this is an exception. So if you don't want to have a movable structure, you by all means follow our standard setbacks, which are 10 and 15 feet in most zones. And you don't have to have a structure.
And I might be jumping to interpretation, but it was my interpretation of listening to the city council meetings and whatever, is that the movable building area they were talking about was related to an easement problem, not just in terms of the whole setback requirement.
The biggest concern is definitely with easements.
Right.
And all new neighborhoods have an easement. So there isn't a new neighborhood with that. Go ahead, Jed.
So I was gonna say, all neighborhoods, they have a 10 and a 5 foot easement, just depends on where you're at. But to Ed's point, you could essentially put bullet points 7 and 8 under item 5 to fix what he's talking about. So if there's an easement, then these two things apply. If there isn't an easement, then they don't.
However, the original point of those buildings that were allowed that close to the property line originally had all those same requirements too. Remember the original wording here was that they could be built within the setbacks if they've met all of these things and were no taller than 10 feet high. So, it had I thought it did, or I could be wrong. Maybe it was just that they didn't need a building permit.
Well, I agree with Ed. I mean, the whole reason the movable issue is in there is if you're in an easement. So to fix it fairly easily is just to move number 7 and 8 as sub bullet points of number 5.
Okay, I'm reading them. Okay, that's great. I love that idea. And so does that mean that someone who doesn't have an easement on their property can put a building within the setbacks area and have electrical and plumbing and everything like that as long as they get a building permit?
Now that's item number 10. We're not talking about moving that item. He says 7 and 8 would go under.
Okay, well, but okay. That's the definition though of movable, right?
No, right now, they don't, if, it's my understanding, and Jed and
Mhm.
Austin, is my understanding that if you are going to run electrical, gas and plumbing and mechanical and whatever, you have to get a building permit for that. You can't do that.
And you can't be in the setback no matter what.
You know,
Easement or not, you can't be within the setbacks. Okay. Let me make sure.
Now. One is
Oh, Marla, we can't hear you.
You're on mute, Marla.
Marla, go ahead.
So three different laws now. One is going to be with the 10 and 15. One is going to be these exceptions to have that within.
Marla, we're getting some feedback. You're not coming through clearly.
or Marla.
Okay, can you hear me?
No.
Maybe
Could
you
you-
could run in here and talk into the microphone.
How about if you type it or type it in the chat and we can read it? Or where Austin is, yeah. Okay, thanks.
She can come to the,
I forgot. I thought she was at home. She's in the city office, huh?
yeah, she's just in her office, so she can,
Okay.
you could just.
I like all of this. I like all of this work that we've done on this, though, that you've done and the city council has suggested.
So my other question, Austin, was it is on item 7, which says the building does not require permanent attachment to the ground, can be moved or relocated within 24 hours. And I got that moved or relocated within 24 hours. So typically most, and again, Jed and Austin stopped me, but it seems to be most things that we have in our code and things can either be, to show satisfaction in code, can either be measured or inspected. So obviously, like when somebody's building and they're putting electrical in their house, somebody comes in and inspects the wiring to make sure junction boxes are put in properly, et cetera, et cetera. Or in the case of before we had, things couldn't be over 10 feet, you could take a tape measure and that. So how does, if somebody gets called in like Ted was, I forgot the new code enforcer or inspector, right? How does he get called out and he looks at this building? How does he either measure or inspect that the building can be moved in 24 hours?
Well, I
Not
think,
permanently attached.
yeah, I mean, I think the
Wow.
first part would be the key part where, it's not permanently attached to the ground. Again, you bring up a good point though. What is the definition of can be moved and relocated? In our last meeting, Alan, it was his opinion that, a 3,000-pound shed is not easily movable within 24 hours, but then other council members felt, that was something that could be moved. So,
Yeah.
it's real, you're right. It's subjective.
Yeah.
Yeah, I mean, again, I'm just worried that we're putting in our code inspector on a spot if we don't define what it means that something can be relocated within 24 hours. Does he just take the homeowner's word for it? Oh yeah, I can move it in 24 hours. What would be the proof that he would give to a code inspector that it could be moved in 24 hours? It has crane lifts on it, hooks on it or something.
I think it's just that it's not attached to the ground. I think that's the whole point, is anything that's not attached to the ground could be moved with enough force within 24 hours. And I brought that up in the other meeting and I said, could we give it a longer time frame? Because are they going to disassemble it or what? And they said, no, because typically if we do need to access that easement, it's going to be an emergency situation. So it will be attaching it to some kind of machinery and pulling it or something like that. And so the only requirement that my understanding was that the definition of a movable building is that it's not attached to the ground. 24 hours is simply the person's ability to get the right machine.
So Jane, where did you think somebody, I mean, I listened to the meetings and whatever, I don't think anybody gave an expert opinion on what was the definition of movable.
That was my understanding of the discussion that I can't remember if it was in our meeting or in planning commission.
Well, I know in the last meeting, Alan brought up that, you know, these things could weigh a couple thousand pounds. And then John had made up that said, well, if they're on skids, you could pull them off. But so is that by those two? I mean, is that the expert opinion we have that defines 24 hours then?
It was discussed in Planning Commission, and I think Shane and Jed, didn't you guys discuss that?
Well, I'm the one who told you that anytime we need to get in an easement, it's typically an emergency. So so I was the one who said it's got to be 24 hours. As far as it being movable, that's a tough one. Like, if it's not attached to the ground, you can move about anything with a track hoe. It's not going to look pretty when you're done with it, but it will get moved if it's not attached to the ground.
I don't know that there's any expert opinions, Ed, on the movableness of a shed, but the bottom line is if they build within that easement, they know that they're saying, I'm willing to take that risk, that if the city or this company needs this, I will have to do whatever it takes to get it out of the way.
Okay, so I'm going to make my general comment here, since it wasn't at the last meeting, is that we used to have a fairly easy ordinance that used to say you could kind of build into this thing if you weren't on an easement, if you were lower than 10 feet, if you don't have the drainage and whatever. And now it seems like we're making an ordinance that was going to have layers and layers of complexity on here. And I'm still wondering what the compelling reason is for the city to move in that direction.
I can speak to what I understand, and then I would like to know what you guys think. But my understanding is that they feel like that they would like this to be more flexible, that they feel like it's a reasonable request, that often people would like to do this. Often people would like to utilize the space in their yard better. And so, you know, they felt like it was worth considering for the flexibility for the residents. That was my understanding. Also, the other thing that I recall being mentioned was that easements are rarely used. I mean, the easement of companies are typically, they're like burying an internet cable or a Comcast cable, and they need 6 inches to actually do it. And so it was giving people more flexibility and ability to use the space in their yard. So that was my take on it.
Yeah, my only point being is that when Austin and Jed looked at every other community around us, everyone said, don't build on easements, period. Makes it real easy, to the point, right? And, you know, I guess we decided that 10 feet or whatever is a necessary place to build. And I'm just saying, it seems like what we're doing is making an ordinance that is going to continue to grow as we figure out we've got some loopholes in our definitions and keep on going at it. You know? Yeah,
those are some good points. I would like to know, Austin and Jed, what is your opinion on why we're considering this? And
well,
city council feels
to build
like
off Jane, to build off what Ed is saying, he is absolutely right. This is going to get more complicated. So in addition to what you see here in your packet, we started thinking about what it means to build inside an easement. And so, and we started to come up with lots of different issues that can occur. So for example, there are fences, if you allow fences, if you allow retaining walls, if you allow, and we have a list of other things. And actually we were drafting, which is really almost a whole nother page of a potential ordinance that would deal with easements. And so we didn't feel like that language was ready to present to you tonight.
Okay.
So that would be a future amendment to the ordinance.
Are you saying that you can't build a fence in an easement right now, and that people can't put a retaining wall along the side of their property line?
What we're saying is a fence could be an issue. So for example, if you had in a lot of these easements, we have public water. So water, help me with the words here, Jed. But basically, like we have a detention pond or something.
Right.
And so if you build a fence across that, you're blocking potential water
Right.
and stuff like
Right.
that. So that could be.
And
Nice.
people know that. I mean, that's already a known thing, isn't it? That you're building, when you put up a fence, you know you're building in an easement and it might have to be pulled down.
Well, yeah, but technically, Austin, couldn't you just attach a track hoe to any of those things? And it might be ugly, but couldn't you just drag them out of the way?
The answer is yes. Right now, our ordinance doesn't have any allowance for any of it, yet we are allowing it. So in a way, I feel like specifically for fences and retaining walls, that happens all the time on the property line, which is in an easement, which according to our current ordinance, they can't build in the easement. So in a way, we need to come up with some kind of language to address that. And that's just, that thought was more or less a side piece that kind of dawned on us as we're thinking about this shed
Mhm.
thing. Like we need to address all the issues.
Yeah, because there are reasons to build in easements, and a fence is a perfect example. Jed, what is your opinion on Ed's question? Why are we even looking at this? And why are we
Well,
doing this when we already had a solution? Why are we considering this?
We're looking at it because of a code enforcement issue and because of some citizens proposed this to us.
Right, but
Hey, so
why did
so
the
I actually
city
have a-
council?
So I actually have a question on that. So let's assume that we do move forward, just hypothetically, and amend this exception, and then it's ratified by, or we make a we make a recommendation and city council accepts, or and ultimately the language is accepted and modified. Is the new language retroactive or prospective only? So in other words, what does that do? I assume currently that there's kind of a code enforcement issue where one neighbor, and by looking at these addresses, I think there must be one neighbor in particular that's got monster shed on one side, monster shed on the other, and has brought the issue to the attention of the city. So there is a code enforcement issue. So assuming that we amend this exception, does the new language apply retroactively to the existing code enforcement pending issue, or is it prospective only?
That's a great question, probably for our attorney that I don't know if he's listening anymore, but just generally speaking, anytime you change the ordinance, if there was something out there that was illegal and now meets the current ordinance, I would say it is now legal. Did I say legal before? I meant to say if it was currently illegal and you change the ordinance and now it meets the ordinance, I would say that now it is legal.
Wouldn't
Know
they
about
still
that,
have
because
to get a
normally
building
if you
permit
have an
though?
ordinance, it is prospective only and typically does not apply retroactively.
Yeah, but
That's an
You're
issue
not-
for the
you're
city
not gonna
attorney, I
go-
suppose.
if somebody has a shed that meets current ordinance, you're not gonna go fine them because it did not meet ordinance a year ago.
Yeah.
One thing Marla was bringing up is that they should have had building permits in some cases. And, you know, that could be a consideration. I know, like, for example, with, I don't know if this is a comparable or not, but like with apartments where they didn't get them inspected, like we gave a grace period for people to come in and register their apartments, get them inspected and things like that. And potentially something like that maybe would help our city where we can have them inspected retroactively. I don't know, that's just an
So
idea.
ultimately, they would have, the ones that are on code enforcement's radar right now would have to come into compliance with whatever the city ordinance is. So if the city ordinance is you're required to get a building permit, they'd have to get a building permit. If the city ordinance was, you know, you have to be under 12 feet 6 inches and they're under 12 feet 6 inches, well, they're now in compliance. So, you know, as long as they're in compliance, they wouldn't have any issues with the city.
Okay.
And if the laws change, they would be in compliance.
Okay, so you actually bringing me to another issue that I was seeking some clarification on, and maybe as a group, somebody recalls this. Where did the number 12 foot 6 inches come from? Why have we fixated on that?
The number was based off of a diagram that Jed drew where it showed line of sight. And so the the residents who put this proposal together felt like 12 6-inches was the right height at which the line of sight would not be obstructed.
Okay, that's what I recall, but let me get some clarification on that. When Jed made that diagram and ran the line of sight arrow, didn't that mean that a 10-foot building on the property line pursuant to our current exception was essentially the same line of sight as a 12-foot 6-inch building 5 feet off the property line?
Austin, is that diagram still in the packet? Do you?
I'm just trying to remember because it seems
It's not in
line of
tonight's
sight arrow anticipated a 12-foot 6-inch building that was 5 feet off the setback.
I don't recall the exact height or offset. I think I want to say that 12'6", if I recall right, it was actually like
No
12
setback.
foot. Yeah, it was no setback.
It was, you started against the property line.
Yeah, and that was equivalent to the same line of sight infraction you would have if you had a 20-foot tall
Right.
shed
Right.
at the setback.
Yeah. There was one point though that Austin did bring up, and that is, I was looking at that as well, saying, why don't we just do 13 feet because it's the same? But you do have some of the side yard views a little bit that it could obstruct too between houses, you know?
Well, the other thought I had is they don't have a 20-foot shed.
No, exactly.
The 12'6" is going to be more imposing on the neighbors than a 10-foot shed because we're not talking about a 20-footer.
Right.
If they wanted to put a 20-footer up, they could. I don't know. That was just a thought, but
But you
I
have
mean,
your 10.
it seems like city council is kind of leaning towards allowing the 12'6" with a 2-foot setback.
Mhm.
The
compromise.
And so, yeah, I think that's kind of where we're at with that number.
So where's the 12'6" number coming from?
Austin, I think it's one of those lower diagrams.
Is it the lower diagram?
That very top one right there shows that a 13-foot tall shed at the setback is just barely more imposing than a 20-foot shed.
And I think the reason 13 is used on here is, as Marla mentioned, it's kind of hard to enforce inches. It would be easier to say 13 feet. I don't know. That was also a comment that was made that maybe, do we really want to get into inches or do we want to say 12?
I can't remember if it was that or if the property owners were requesting it, but I think what happened was the property owners came back and remeasured and said 12'6" is all they needed.
I think they saw that 13 was an issue, and so they thought, let's go shorter than 13, so it's not an issue.
So, all right, so I'm looking at the screen you have right here. I'm looking at the upper yellow box. A 13-foot tall shed would have to be placed approximately 5 feet away from the fence to not create a worse view angle than a 10-foot tall shed. Okay, that's what
with no space.
Yeah, so basically if you put a 10-foot tall shed pretty much on the property line, right?
Yep.
And if you put a 13-foot tall shed 5 feet off, that's about the same view angle, right?
Correct.
Yeah.
So what seems to me now is we've sort of haven't mixed apples and oranges here if we're now saying that, because we're saying that, well, a 13-foot tall shed is the same as a 10-foot tall shed if it's 5 feet off. But now we're taking the 13-foot tall shed and putting it 2 feet away from the property line. So it's no longer a consistent view angle. So that aggrieved neighbor it's not the same to the aggrieved neighbor, correct?
Yeah, it depends on which shed you're talking about.
Well, I'm talking about a 13-foot shed 2 feet away from the property line isn't consistent with a 10-foot shed on the property line.
Yes, you're
That's what
correct.
we said before
Right, but
was.
also,
if you
Alan,
took a 13-footer and moved
Mhm.
5 feet away, that would be
Yeah.
consistent with the 10-footer. But we've now taken that 13-foot shed and moved it 2 feet away. So
Can I
it's
make
not
a
the same
point?
view angle.
Part of it too, when Jed's saying depends on the shed. If you have a shed that is 10 feet high with a slightly angled roof versus you have something that peaks in the very center at 13 feet, that could be a little bit different. You know what I'm saying? Like with a shed roof, shed.
Yeah, I actually drew them purposely in the worst case scenario where the
Right.
highest point closer to the property line.
Yeah.
But also to the point, are we comparing the view angles to the 20-foot shed or the 10-foot shed as currently allowed by ordinance? And I think that's what you're getting at there. Because a 12-foot shed, any shed taller than 10 feet right on the property line is obviously going to be worse than what our current ordinance allows.
Right.
Jane, can I go back to what Ed Bush said?
Yes, please.
So what I'm hearing him say is that city council is changing this ordinance for easements only. But when people come into my office to get a permit, I've gone over that 6 criteria. This is where you can build your shed if you meet these 6 criteria.
Mhm.
But if we're lumping this and changing that criteria all into one, does this now need to be split into 3 different criterias? One if you're in
Okay.
an easement, one if you're just in the under 10 feet, and one if you meet the 10 and 15. Because
Mhm.
it's confusing to me how now you're saying what we're changing only applies to easement properties.
Okay.
That's going to be super confusing to the residents, I think.
Yeah, so you're saying we've got to look at the setback as one situation, the easement as another situation, and
Yeah.
then the height.
Yeah, what she's saying is right now, the current ordinance applies to setbacks as well as those as easements that would be inside those setbacks. So
But we
It-
did
it's an
realize we were
all-
missing.
it's a catch-all right now. So
Right.
if we break it into little pieces, then it
Mhm.
gets more complicated.
Right, but our current ordinance, we realized was actually lacking an element because our current ordinance was not addressing easements at all.
Well, it was, because if someone came in to DRC and said, here's my plan, Austin would look it up and say, no, you can't do that because it's
Oh,
in an
okay.
easement.
Okay,
Nothing was allowed to be built
Yeah.
in an easement.
okay,
I mean, the
I
idea
understand.
is you get an exception to a setback but the city wrote that knowing that easements are located inside setbacks.
right.
So we would look at each individual permit that came through. That's why it's important
Mhm.
that residents come in and ask questions and get permits before they build.
Right,
And they were told, no, you cannot put it here because there's
Mhm.
a gas line under there, or this is an easement for a trail,
Mhm.
or what have you. So this ordinance does not apply to you. This 6 criteria does not apply to you.
Mhm. Well, go ahead.
One other question I have, and this, so besides the confusion that look, I mean, Marla's there in the office where the rubber meets the road and where these ordinances are actually discussed with city residents and implemented. And number one, to Ed's point that, well, what's the purpose here? Besides the fact that now we're injecting a lot more confusion into the process. And again, maybe we can work through that with maybe 3 different situations, but I honestly continue to be confused about the motion back from the city council. And I'm sorry to get into this again, but I thought I understood that there was a 4 or 5 member agreement and vote and mandate from the city council on a 12'6" height to be implemented into this exception. And then I heard, I think Austin say today that the 12'6" was clear to council member Thielen, but that perhaps other members of the city council weren't so sure about the 12'6". and that maybe as a planning commission, we're supposed to consider 12'6" or some other height. And I continue to be confused by a less than clear motion from the city council that apparently didn't get clarified any further in the council meeting from last week.
So to that point, Alan, whenever we have like a legal case or something that comes up, the minutes are the legal document. So whatever's written in the minutes, that's the legal phrase. That's what's recorded. That's what's binding. So the way it's written, that's what should be gone off of, not what someone's opinion or interpretation of that is, but the actual written word.
Well, Austin, I think that you said that there was some difference of opinion between certain council members about what had actually come back to the planning commission as far as whether we were to implement guidance and language around a 12'6" maximum height, or if it's some other number that we think is more compatible with the city of Alpine and its residents. I'm just still trying to understand which is it.
Yeah, I'm gonna put the motion here on the screen.
Okay, that's fine. And could I just say that my general understanding is the city council has come back to us and said, we want to allow sheds to be a little higher than we have in the past. And we want to allow them to be within the easements if they're movable. Will you craft language that you think best suits this situation and protects the city and the citizens? That's how I feel like the directive from them is at this point in time.
It's not what the motion says.
Right, I was gonna say, if you read the motion, that's not what they gave to us, Jane.
Okay, that's, I guess.
So, I mean,
point.
the person that made the motion has a certain understanding of what they were trying to say to everyone else. The people that voted to approve that motion had an understanding of that motion, the way it was stated in the meeting and the way it's written in the minutes. So, you know, I guess it's the planning commission's prerogative to interpret this motion the way it's written and according to your understanding, make a recommendation to the city council.
Yeah. And I guess my summary is the way I understood this to be. And maybe I'm wrong, but my understanding is that the city council is saying we would like to have these buildings a little higher and within the easement, and we would like language crafted to do that.
My interpretation is different.
That's fine.
Right.
And kind of, you know, whether we, the good question is whether we agree with it at this point or not. You know, we originally had sent the motion over that we thought it should stay the same. And I guess that's why I'm not saying necessarily that I am in agreement with it, but my understanding is, and I don't know, Jed and Austin, maybe you can speak to this a little bit, but if you were to summarize why we're sitting here discussing this, what would you say?
I would just say that there was a motion made to send this back to planning commission to reevaluate the setback exception criteria.
Okay. And so if we send it back again saying we think it should stay the same, and is that accomplishing what you think we've been directed to do? I don't think it is, but.
I think they're wanting some change. That's my understanding of it. But again, that's just my understanding of the situation.
Well, right. And I mean, that's why they sent it back twice now.
So Jane, I thought Commissioner Thielen made it pretty clear that they expected us to send something back that was different.
Right.
Yeah, but I will make the point, right, which one point I make is that I felt that in looking at the meeting, it was totally inappropriate that Jason Thielen was there to give one opinion of the city council when 4 members voted for this resolution. So what you got was Jason Thielen's interpretation of what he wanted to be in the motion. What
Okay.
you didn't get was what was Lon Lott's interpretation, what Jessica Smoothen's interpretation was, and Greg Gordon's interpretation of that, who voted for that motion, because there's a lot of interpretation that could be made in this motion.
Okay, that was probably, I should add, that was probably my mistake. I mean, Jason had asked me earlier in the day if I felt like we understood the motion that was made. And I talked to him a little bit and he said, do you think it would be appropriate for me to come and just make sure that it was understood? And I said, sure. Why don't you come and just make sure that we understand the motion that you made? And so I'm sorry if you felt like that confused the point, or that we should have had every single person come who voted for the motion. But I thought that, one person representing the motion was fine.
Yeah, I'll bring up the point. If you listen to the last city council meeting, Austin brought up under communications that there was a question from a planning commission member, that was me, over trying to get some resolution, because I watched the swirl that went on in the planning commission meeting that I was not at. And Mayor Stout said to Jason, why don't you write something down in terms of what you meant by the motion? And Councilman Lott said, no, I don't think that's right, because I might interpret that motion differently than the way Jason did. Right. So that's only my point, was that I don't know if they're all in agreement of what the direction they were giving to us.
So Ed, what is your suggestion then? I appreciate all the points that you're making. What is your suggestion that we do tonight then?
Well, I mean, we could do a couple of things. One is we could take a look at what I would interpret this to say, is 12 feet 6 inches acceptable to Alpine? Yes, no. Would we have another number that we want? Or do we think the movable accessory building would be allowable within the setback? If the planning commission thinks that this is going to be an onerous ordinance to maintain and to measure or to whatever, I think it would be perfectly reasonable to say we would recommend not following, other communities or whatever. Or the other option I would say is we could table this and actually make a formal request to the city council to give more specific direction to the planning commission as to what they would like to be done here. One of the things that Jason said is that, gee, we could clean up some of these issues if we had better communication. I don't know if there's any other way communication that we can do other than sending a request to them to say, gee, we would like a better definition of what the motion said.
I mean, I think we need to keep in mind that we're trying to work, whatever we do, we want to work as partners with them and have good communication. And I mean, their intent is to do the best for the city, as is our intent. And I think we just need to maintain that and a good relationship with them as we do it. I think all of those things are perfectly great. And I think the whole point of what we're doing right now is discussing exactly what you said. We should be discussing, is 12.6 good or not? Is a movable building in the setback good or not? And then if we discuss it and think not, then we make the other motion. So I think rather than discussing our frustration with what the city council has sent us back or lack of understanding, let's discuss those items that you said. And if we feel like we need more direction, then let's just go straight there so that we just stay on a productive route.
Yeah, Jane, I agree with you wholeheartedly. I'm just trying to address where people have made the comment that says, we believe the city council has directed us to change the ordinance, right?
Okay.
That's where I believe that if they wanted to say that, they should have said that in the motion, right? Otherwise, then I believe it's up to us to decide what kind of recommendation we want to give back to them.
So Ed, and to your point about the communication, so following the meeting, Councilman Greg Gordon and Lon Lott did approach me each separately to kind of explain the way that they understood it. And both of them basically essentially agreed that they understood the motion as it is written, meaning that it's a little bit more open-ended than some others have interpreted it. So I don't know if that helps or not, but the way that the reason why they approved it is because they liked the way that it was stated in the motion.
So why don't we move forward and say, let's discuss the height, yes or no? Let's discuss the setbacks, yes or no? And take some concrete action on this? Are you guys okay with doing that? Or do you generally, does more people than Ed feel like we need to send this back and say, you know, we don't think this is worded in the way that is telling us, you know, what you want us to do or whatever. We want you to reword this. John?
I'm ready for us to make a motion on the ordinance amendment and see where we are.
Okay. Do you want to go ahead and make a motion? And then one approach is, and this is a perfect example of why we were coached a few years ago, and I struggled with it at that time, but to make a motion so that we had direction towards what we were discussing. And I guess maybe this is one of those situations where somebody make a motion, we can discuss that motion. If you don't like it, we stop and we start with a new motion.
The only adjustment that I would make, I'm not able to see it here on my phone, but is it paragraph D that all these exceptions fall under?
Uh-huh.
On the last line there, it says required. And I would want to see that changed to may or some other accommodating language. It suggests
the building does not require permanent attachment to the ground.
No.
Let's see.
Go up to the leading paragraph to all of these requirements.
Okay.
Okay, so paragraph D.
Yes.
That last sentence says.
Oh, setback shall be required. So a 2 foot minimum rear side or setback may be allowed when all the conditions are met.
Exactly.
Okay.
Instead of required, because we're not saying that you have to
have 2
a 2 foot setback. We're just saying you may
you
go
could
up
go
to
less.
a 2
You could go 3 foot or 4 foot.
Exactly.
So, okay.
So however we want to codify that, but I would accept as written and make a motion that we recommend approval of this modification.
Okay, go ahead, John, finish.
I don't have the ordinance number up here.
So basically though, let me just point out one thing really quick before we finish the motion. That it says a 2 foot minimum is required. That means if we take the word required out, that means it can come closer than 2 feet. So I do think 2 foot minimum is required. That means it can go bigger than that, but it can't go less than that.
That's right.
So I think required is okay there. Because if you change
minimum?
it to, yes, it does say minimum. It says 2 foot.
Okay, you're right. I'm sorry, I missed that one. Okay.
So that's okay. Okay, so your motion is to approve it as written.
Yes.
Okay, so we have a motion by John McKay. Do we have a second? Okay, if nobody wants to second that motion, then it dies. Do we have another motion that someone wants to bring forward?
So, okay.
We
So,
can discuss
quick
it, like
question.
once we, okay, go ahead.
Can we, okay, so Ed laid out a couple options, right? Option one, let's work on some language and we'll send it, about increased height, setback, easement, etc. And then we'll just send it back to city council and they can, accept it or not, right? But we were. Option B is send back, do a motion and just basically send back to city council for a clear directive, right? A clear motion. Can we just, so we advance the ball, can we just is it proper to take a quick straw poll of
what do we have here? 1, 2, 3, 4. How do we have 5 here or
I
6?
think you just need to make a motion and second it, and it either dies or moves forward. But I corrected there. I don't know if Hiram or Austin or Jed have a comment on that. Hiram?
Yeah, fine to have an open discussion if you want to say, hey, do we feel, do people
Is it
generally
okay
feel
to kind of take
okay
a
with
straw
this?
poll?
It's
Would
not
you
going to be an
guys-
affirmative action, right, until somebody makes the motion, actually.
Okay,
But if you want to say, hey, I'm feeling this way, how does everybody else
okay.
feel about pushing this back up? Would anybody
Okay.
have an objection with that? And then, but it wouldn't constitute any sort of formal action until somebody makes a motion.
Great.
To do
Okay,
that.
thank you for clarifying that. That's something I've wondered before, Alan, so I appreciate you bringing that up, is if we can just say, like, how would you feel about this? What would you think? So go ahead, Alan, with that and proceed with your idea and kind of take a straw poll.
Well, you know, my idea is just to I can't see everybody right here. So I know there's me, Jane, Ed, Troy, John, Ethan. So we got 6 of us, right? Okay, we're only missing Sylvia.
Right.
So Jane, maybe just, I mean, because I can't see everybody. I mean, Jane, maybe just take a quick poll, ask each of us, do we want to send it back, or do we want to work on language?
Okay.
You can just,
All right.
okay, well then if it's more of us than not would rather send it back, well then let's just, then we can short circuit, and then we can work on a motion to that. If
Sure.
more of us would rather, no, they send it back, they want something, we'll do our best to send them something for the citizen, you know, the residents of Alpine, then work on that.
Okay, so Alan, go ahead and tell me what your opinion is on that. How you feel.
Work on it.
Okay, Ethan, how do you feel? Do you want to work on it, or do you think we need to send it for more direction?
I want to work on it.
Okay, Ed, how do you feel?
I think we should work on it.
Okay, John?
Work on it.
Okay, Troy?
Yes, I definitely think we should work on it.
Okay, I feel the same way. So I think
Okay,
let's go
then
to
if
the
we
items.
want to work on it, then what was it about, then what was it about John's motion that nobody wanted a second? So what do we need to focus on to get this into a workable format that we can then make a motion to send it up to City Council for review?
That's a great question. And since I can't make motions or second them, I need to hear from you guys.
So you can't make motions, but you have.
I can't
Sorry,
second
go ahead,
them or
Ed.
make them.
Yeah, so I'll just jump in. One is that I'm not so sure I'm sold again on 12.5 feet as being the roof line. But if we're going to talk about sending something back for movable buildings, I think item 7 and item 8, item 7 and item 8 need to be sub to item 5, so that it's only the situation of when we're talking about building on an easement that that has to be movable and that the owner acknowledges they bear all costs, etc. But if they're not going to be imposing or building on an easement, you don't have to have a movable structure.
I agree with that. Any other comments on that?
Can Austin share the document? I don't, it's not up on my screen anymore.
Okay.
Did we lose the document share?
No, he just took it off so you could see who was here.
Oh, gotcha. Okay.
Yeah, I think that was my general disagreement.
If we were just going to work on this thing, starting from kind of the top going down, well, the first issue is, I think, height, correct?
Well, 2 foot minimum, do we all agree that 2 foot minimum is fine, or do you want to change that? That's the first thing.
So again, let me just remind you why the 2 foot was selected. So the idea is we want to accommodate the eaves of a structure and also to prevent drainage onto a neighboring property. So it felt like a 2 foot buffer minimum should be required. A 0 setback we measure to the foundation, so I could measure to the side of the structure, but if his roof hangs onto his neighbor property,
Mhm.
you know, that's a problem. So
Yeah,
the idea is, why don't we say 2 feet so the side of the
like
roof can
that.
hang off a little bit.
yeah. I
Okay,
also
so-
think it gives way for perhaps inaccurate property lines that we thought we knew.
Okay, so if it's 2 feet, then we're going to move to section 5, which is allowing residents to encroach on utility easements.
Right.
So we need to figure out if that's something we're comfortable. I think if I'm just going to go in order here, trying to
Mhm.
divide at
So-
a time,
Yeah.
it isn't the next issue. Okay, the 2-foot provision then assumes we're going to allow people to put a structure in an easement, which means that we've got to get into the movability. So, so do we think it's a good idea to go back to the original motion, right? Do we think it's a good idea for the city of Alpine, its residents, to allow them to encroach on that easement with any kind of accessory building?
Alan, I think we might be missing one thing, which says that they will get an agreement from the owner of the easement.
Yeah,
That
but
they
that's,
said they're
that's part
okay
B,
with.
right? I mean, if we decide, no, they shouldn't be in an easement, then we don't have to get to, unless you get permission.
Okay,
So-
I
so
was
I
just
guess what
saying,
I'm
I'm
saying
more comfortable with them being in an easement. That changes my mind about being in an easement. I'm okay with them being in an
But if you're
easement.
gonna get, okay, so let me ask you this question then.
Mhm.
If you get document from the owner of the easement that says, oh yeah, you can encroach. And
Mhm.
I don't know whether that's possible or impossible to get. But even if you
possible.
get
Mhm.
an agreement,
I've had some dialogue with local citizens that have dealt with that issue recently, and apparently it's a very common thing
Right,
that for the types of easement permissions we're talking about on these side yards in particular and the backyard lot easements, they're just done perfunctory. It's not an issue at all.
okay, well, that's great input. Good to know then. So then at that point, because if that's doable, then we'll get into the movability issues, right?
Mhm. And what that says to me is that the owner of that easement thinks it's very unlikely they will access that easement, or if they do, 2 feet is enough.
Okay, so then it seems like the 2 feet is okay, and that we can also allow encroachment onto an easement, because it sounds like that's fairly perfunctory to go ahead to get that letter, right? And then we can get to the movability in a little bit. I don't remember what Ed indicated that we'll have to move some things around, but now before we get to the movability, now we're getting to height.
I've got.
And the question was, I remember Marla saying a couple of weeks ago, well, 12.6 is kind of a pain in the butt. Why not 12 or why not 13? Why 12.6?
I think we talked back and forth about that. I believe it was the people who are putting the proposal together had requested that, but also I think that number could be anything. I think we can look at different sheds as a standard. We can look at the site angle if you want to.
Well, I think standard sheds are about 10 feet, at least your standard shed, Home Depot, a pretty nice shed. When you get into a custom shed, I don't know what's standard, because typically custom means it's not standard.
Well,
So I don't know what a standard custom shed is.
So what criteria do you want to choose the height off of? So
I don't know. The only reason we've chosen 12.6 is because somebody has a 12-foot, one of these applicants has a 12.6 shed.
So
that might be where it
13,
came
we'd
from.
be talking 13.
if I may.
Or 14, I guess we'd be talking 14.
Austin, please.
Yes, thanks, Jane. So if I may, honestly, if we're looking at this and we're saying, okay, we have three individuals that came forward, they they put this proposal together, 12 feet 6 inches. That's not the only issue that code enforcement is dealing with. So we actually have other ones that are taller. So we have some that are 14 feet, 14 and a half feet. You know, if we wanted to make everybody happy, you could just say 15 feet. You know, that's the, you know, whatever, you know, it depends on what number you want to go for, but the 12 foot 6 inches, the reality is that came from those 3 residents. That was their proposal and based on their understanding of Jed's drawing.
Right, but so why don't we make the 15-foot people happy?
They didn't bring the proposal forward. No.
Yeah, but we're
Alan,
trying to do this
so-
for all residents,
so
right?
The point is, what do you want? That's my question is, what do you want to base the height off of? Do you want to base the height off the site angle? Or do you want to base the height off something else?
Well, you look, if it were up to me, I would have left the original one, but that, you know, that's fine.
That
We
ship
took our
sailed.
swing and it was, you know, no peanuts for you.
Yeah.
So I don't know. I mean, maybe I would seek, to me, it's completely arbitrary. 12, 13, 14, 15. I mean.
Why do we have
maybe
20
Jed
feet?
has input on that. I
Why
mean,
do we
maybe
have 20 feet at 10 feet in?
Marla.
Can I ask
I
that
have
question?
but
Why do we have
I
20
have
feet at 10
really
feet in, Jed?
I really don't have any input. I mean, I feel like it's arbitrary.
It's
So, okay,
because
so it's arbitrary.
Honestly, yeah, we don't know where, we have, our current setbacks are 20 feet for an accessory, I mean, a height of 20 feet for an accessory, 34 for a home. Those are the numbers. I don't know where they came from though.
It's because at 20 feet, you're talking about a garage. You're
Right,
not talking about a shed. That's why.
yeah,
I mean,
standard garage.
We can sit here and compare that height to, you know, the view angles of a 20-foot shed and whatnot, and move it or slide it around within the easement or the setback area and look at it. But in all reality, it's the number that the applicants have proposed the city council, and city council's told us to consider that number.
Well,
Isn't
and-
the whole purpose of the sight line, shoot, just a second, I forgot my question. Yeah, isn't the whole purpose of the height the sight line, right? That's the whole,
Yeah, I mean,
So on that
Yeah.
point though, the 10 foot that we allow inside a setback right now, that was not based on line of sight. That's not the reason why that number was chosen. It was
Okay.
chosen because that's the common height of a tough shed. If you go to a store and you buy a non-custom shed, that's the common height. That's why that number was chosen. Nothing to do with line of sight.
and really, the height of these sheds, it can be the height at the beginning of the shed, like if the shed were to have a flat roof. There's a very big difference between a 10-foot flat roofed shed and a shed with a pitch that has 12 feet in the center. It's going to be, you know, lower on the sides too. So, I mean, there's all kinds of roof lines that you could get into if you really wanted to as well.
Yeah, but we're
Yeah,
defining
I mean,
height.
that's why I'm saying I would have just left the original one and said, look, if you want something taller than 10 feet, then abide by the setbacks. But, you know, some people came and said, well, I want a shed and I want a custom shed and I want it inside the setback. Oh, and by the way, my shed's 12 and a half feet, so let's make it 12 and a half feet. But if somebody would have come that had a 14-foot shed and said, yeah, well, hey, well, look, I got this shed. I spent a ton of money on it. It's 14 feet tall. Then we'd be talking about an equally arbitrary number that's 14 feet tall. So
Maybe not. Maybe city council wouldn't have sent it back. I don't
well,
know.
I'm just saying, but if it's 12.6, I mean, are we going to have now the 14-foot shed crew who's going to say, wait a minute. No, we're going to be back here next month with the 14-foot shed crowd wanting another amendment to the exception.
Well, maybe what we need to do then is pick a height that isn't arbitrary.
I know that, but I've asked that, Jay. I don't know what a non-arbitrary height is.
Well, I mean, I think that you can use off of our other ordinances, the 20-foot. To me, the only thing that's not arbitrary is to use the 20-foot line of sight. But, you know, otherwise, or if you want to look up, maybe the standard tough shed has increased in height. I don't know. But if, I don't think, you know, it's some of these things are based on interpretation, you know, but you think is acceptable. I mean, Sylvia had showed us the examples of what a shed looks like to the neighbor, you know, what a 12-foot shed looks like to the neighbor 2 feet away. And, you know, it's significant. There's no question about that. I don't know, like I said, I don't know, you know, we could say height at the peak. If you want, you could say, you know, no higher than 10 feet against the property line and no higher than 12.5 feet at the peak. I mean, you know, there's a lot of stuff we could get into.
So, yeah, I don't want to belabor the point. We should just move on. I guess I'm just pointing out that it is completely arbitrary. It's just a number given to us by those, you know, an amendment to the exception. One's as arbitrary as another, really. I'm fine going with 12.6. It's just basically to accommodate one crowd, and we're, you know, but it doesn't accommodate another crowd, it sounds like. I mean, if we went 12, then we got people who, well, what are they going to do? Slice 6 inches off? But if we go 12.6, it sounds like there's other people, and what are they going to slice off? 18 inches? I mean, I guess you got to pick a number at some point.
Right, pick a number or pick a reason for that. Like I said, I mean, I think the only thing you can do if you want to have a reason for the number that will not be changed by other people is if you take the 20-foot sight line, you draw your angle and you pick what number it is at 2 feet out. Then you
What number is that?
I don't know. Let's pull it up, Jed. Do you have that file open, Jed, that you could do it? I mean, I can pull it up and I can draw it in get my geometry tool out here and we can pick what that number is.
I thought 13 may hit that number.
Yeah, I think it was 13.
13 is at 5 feet out.
I do not have that program open, sorry.
Here, let me see if I can find it while you guys, why don't you discuss the other point and let me just do a quick, I did used to teach geometry. I can calculate it for you. I'll get it for you in just a few minutes while you guys discuss the next point.
We just had those measurements up a bit ago. Who had those?
Yeah, but he has it at 5 feet. He doesn't have it at 2 feet. Right? So I can let me just change it to 2 feet and I'll calculate it while you look at the other items, okay? Discuss what makes a shed movable while I calculate it for you.
Well, just one more thing on this topic is that we moved the shed back 2 feet. So the same shed will not be obstructing the sight line at 12 feet as much as it would have.
Right, but I'll calculate what the sight line is at 2 feet out to let you know the maximum shed height that matches the same triangle. We'll do a similar triangle.
Okay.
Figure out what makes a movable shed, guys.
I've got a question. Would a utility company actually give you permission to build on an easement? I mean, they don't care if it's permanent or not, right? I mean, they wouldn't give you permission to, you know, hey, I mean, like if you said, hey, it's a movable shed, would a utility company, is that going to make a difference?
Yes, it will, because they're not abandoning the easement. So they don't abandon the easement. They're just giving you permission to build something that is movable on the easement. It's very specific that way.
So that makes a difference. If I go down to the utility company and say, yeah, well, I can move this shed, and that really, okay.
It might make a difference.
That's my understanding.
Because I thought they'd either say no or yes, you know, hey, if we're ever going to use it, we'll put anything on there, you know, but if you're going to use it, put a cement building, I don't care.
Yeah, I mean, to vacate an easement, that's one thing. So like, again, to return to the Alpine Fitness example, there was an old gas line there that was no longer being used. However, there was still an easement that ran right through the middle of that property. And so the Alpine Fitness went to the gas company and said, hey, are you okay to relinquish your easement there? And if so, can you sign this document? And so that's what happened in that situation. So, I mean, to vacate is different. To vacate the easement is different than to allow someone to encroach upon an easement. You're saying we may use that easement in the future. And however, we're okay with the movable structure because we feel like we could still access it if we had to.
Yeah, are they gonna, I mean, yeah, do they care? Like if I go down there and ask permission, are they gonna care if it's Either they're gonna say yes or no, right? I mean,
Probably,
I don't,
yeah.
I just don't see that
Yeah, it's just
making
gonna
a
be yes
difference
or
if I
no.
say, hey, well, I can move it. Oh, well, then we'll give you permission, you know? I don't-
Yeah, yeah, they're gonna be like, can I encroach in your easement? Yes or no?
Yeah, it's either gonna be yes or no,
Uh-huh.
and if it's a, yes, because we're never gonna use it, so go ahead and build a permanent building on it. You know, I don't.
But that's more of an abandonment. And so I think the point is the city, that's why we're here saying we're gonna protect our citizens from doing something stupid and putting a permanent structure in an easement that's not abandoned.
Hey, Jane, work on your calculation.
Sorry, I am doing it right now.
I think the movable language is pretty good. How do others on the commission?
I think it's fine. I think what it does is it puts citizens on notice that they need to consider this in their structure. It's not up to us to decide what constitutes anything more than what we have of what's movable or not.
Yeah, Alan, this is Ed. My only comment is that I think I again, to kind of relieve, pressure on the citizens, if we're going to put a movable requirement in, I would put paragraphs Roman numeral 7 and Roman numeral 8 under Roman numeral 5 as subheadings, because I don't think if they're not encroaching on the easement, do we really need to have them have a movable building?
I think we're all in agreement on that.
Okay. Thank you, Ethan.
So has Austin or Marla captured that comment? Can we have that reflected back to us
Which comment?
of moving those sub points underneath, what is it, 5?
Yes, I have Ed
Underneath
Bush.
5.
Yeah, Ed Bush said that if we put in a movable paragraph, the language needs to be under the subhead of number 5, sheds on an easement.
Okay, captured.
So, Austin, I have a question for you. Is there, I mean, other than we typically like to get things done as expeditiously as possible, where it's the middle of February and it's foot of snow outside, there's not a whole lot with this accessory buildings that are going to get done until spring. I'm not saying we wait until spring, but is there any value to continuing to kick these things around for another few minutes? Make sure that we're addressing Ed's concerns that we have the right sections under the right sections, that we aren't mixing setback versus non-setback buildings. I'm really, I tell you, somebody who I think has really invaluable feedback on this, to take a look at refinements and refinements upon refinements and refinements upon those refinements, and then be happy with the outcome, might be Marla as well. And so is there any value to continuing to refine this based on our discussion points tonight, and then look to have a final amendment in place in a couple of weeks that we can then send on up to City Council? Or is there a time deadline that we think that we need to get this in final form tonight?
Yeah, great question. I think you have time on your side. So with regards to these 3 residents who are petitioning the city for, that have requested this, code enforcement has extended their deadline until June to come into compliance. So they're no longer racing against the clock. The previous deadline was the end of February. And so they were kind of hoping that this would all wrap up before the end of February. It looked like discussion was going to potentially continue. And so code enforcement has given them until June to come into compliance. So I'd say if you feel like tabling it, by all means, I think that's an option.
Yeah, I'm not trying to kick the can down the road necessarily. And I think we're usually pretty good about getting something done in the particular meeting. And now this is meeting number 2. But I also just want to make sure that we get this right, that it works for now and in the future. And I just, one thing that you and Jed said that struck me as well as Marla was just, you're thinking through unintended consequences and how might this impact other sections of the code where things might be within setbacks and or easements. And so it just seems to me this might be one of those situations where you go back to the drawing board one more time. I think we made significant progress tonight, but maybe you go back one more time, come back with a final version that particularly the three of you, Austin, Jed, and Marla, feel like really is workable. And we've thought through intended and unintended consequences, and bring something back to us in a couple of weeks. It's 98, 99% done.
Mm-hmm. Just unless I calculated it wrong, the very edge of the building, it's like 10.5 feet. So Ed, you can pull out your similar angle calculations and see where I'm at. But to Alan's point, I think if we want to add the fencing and the retaining wall and just do it all at once, that's another thought. Because
Couldn't your language just be structures instead of sheds?
right, something like that actually will take into account things like fences. I mean, chicken coops. I mean, I don't know. There's all kinds of things that people could put in the easement. Just like you said, structures of any kind. Retaining walls might not be considered a structure. I don't know.
Aren't those different parts of the code there? Aren't we just talking about accessory buildings
Yeah,
here?
I really don't think those fit under here because this is
Okay.
just an exception for accessory structures. That's what this criteria that we're looking at right now. So
Good point.
honestly, I think it'd probably be better if we come back and hold a separate public hearing
Okay.
for those other items.
But Austin, the confusion is when a builder comes into me, they're filling out an accessory structure for that retaining wall. It all falls under.
Oh, really?
Mm-hmm.
That's interesting.
So our retaining wall application is our accessory structure application. Is that what you're saying?
What she's saying.
Okay.
So
Yeah,
maybe that's another issue.
Maybe we need to
So-
rethink that.
Yeah, so the building department is just, we've just thought of that as an accessory structure.
Yeah.
So if we want to separate it, that's great. I think that's a good idea.
I think they're unique enough that we should probably consider them distinctly. They both require inspections, as far as the building department is concerned, and they both require plan review, but
Unless
they are
shorter
different.
than.
They are different animals.
Yeah. The retaining walls don't have to be inspected if they're shorter than 3 feet or something like that, do they?
4 feet, correct.
4 feet? Okay, so do we need a motion for what we're going to do?
Well, so real quick, Jane, where did you come in, sorry, with your, if you were trying to ground a height in some tangible measurement,
Mhm.
something that's just, objective and non-arbitrary, did you say when you were running your line of sight calc, what'd you come up with?
I came up with just a little over 10.3 feet. I don't know. I just used a right angle.
Well, see, there's the genius of the original exception.
So, yeah. So I was gonna say, now I'm nervous that I ran my calculations right, but that's what I just did. There's actually right triangle calculators online that you can just put in the different numbers and they'll give you the angle. So I'll just verify that I did it right. But yeah, that's what it did. So
We can't come up with a rationale. We just need to accept 12.5 feet.
yeah.
I mean, honestly, almost any number you pick is really going to be, it's hard to not make an arbitrary number, I guess.
It really is. It really is. So.
Well, I know a couple of weeks ago, Marla, had some pretty strong feelings about the 12-foot 6-inch number.
Mm-hmm.
Well, and I know though that part of the idea here was that they're saying, hey, what these citizens are asking for is somewhat reasonable. So if we were trying to accommodate them and we come up with 10'6", we're not accommodating them.
Right, but if, right, 10'6" wouldn't, and but maybe just, a flat 13. I don't know. I'm just always sensitive to having ordinances, work in the real world. And,
Mhm.
I just recall, Marla having, a fairly grounded and strong opinion on the issue. And, to me, that is an opinion worth considering rather than just an arbitrary 12'6" because somebody built their shed that tall.
Yeah, no, I agree.
Yeah.
I'm just saying that if we come up with a shorter number than that, then we did not address what the city.
We're not addressing the issue at hand. Yeah.
Yeah, clearly the city council feels like there's something worth looking at
Right,
amending our
yeah.
ordinance for.
Personally, I'm okay with going with 12.6 because that's what the city council felt like was reasonable. It did come from the citizens, but they felt like it was a reasonable request, so.
Now, my main argument for that number would be that it's closer to the 10-foot that we like. So I would be as short as possible.
I also think it's highly unlikely that the 12 feet 6 inches will be on the edge of the building. I feel like it's much more likely that it will
Sure.
peak. And I also think if we wanted to, we could word that.
That's usually the same deal with the 10-foot though, too. It's usually 10 feet at the peak.
Yep.
Not the
Yep.
beginning of the roof. But
Yep.
I'm not sure really that a motion needs to be any more in depth than just table for an additional 2 weeks for staff to review the suggestions and modifications discussed by the Planning Commission in today's meeting. It doesn't need to be
Can
much more
I-
specific than that, does
Can
it?
I just ask, what is it we want them to look at further? Because I feel like.
I think mostly at this point
Everything.
incorporating that there needed to be an incorporation of Ed's concern that he voiced, and I think he understands a little better than I did. I'll defer to Ed on that.
Oh, yeah, so I guess my suggestion was, again, Ethan could probably do this one, but 7 and 8 need to be subparagraphs to 5.
Yeah. But I feel like that's something that we can just say right now. Like, is there something that can't be done in this meeting that we need staff to do? Because if not, I feel like we should proceed.
Okay, so I'm going to make a motion here, Jane, because
Okay.
I don't know. I guess to a certain point, I'm getting tired about talking about sheds.
Okay.
So I'm going to make the motion that we accept the proposed, that we recommend to the city council the proposed ordinance, whatever it may be here, setback requirements 3.03.050.2 under accessory buildings, subparagraph D, side and rear setback, with the following exceptions. That we move paragraphs Roman numeral 7 and Roman numeral 8 under Roman numeral 5. And any other, and then, whatever grammatical additions need to be made to make that work.
Okay, we have a motion by Ed, we have a second by John McKay.
Yes.
Okay, do we have any discussion on the motion? Does everyone understand what Ed is proposing?
So it's basically the same thing. He's just moving that, right? He's just moving those two under there so they,
So that they only apply if they are encroaching on an easement.
yeah.
Okay, any discussion that anybody wants to have on that? Okay, then we'll go ahead and take a vote. So Ed Bush,
Aye.
Ethan Allen,
Aye.
Troy Slade,
Aye.
Alan McDonald,
Aye.
John McKay,
Aye.
Jane Greiner, aye. Okay, so that motion passes and it will go to city council for their review. And Austin can bring back to us in another meeting issue of retaining walls and fences currently being built on easements. Any wording around those, so. Okay.
Plenty more easement fund to come, so hang on to your.
I think that was a tough issue, and I think all of our points were very valid concerns and well thought out. And I appreciate everybody's thoughtful consideration on it. And we will move forward now with the next step of our meeting, which is the communications. Anyone have anything for communications?
Jane, I have one communication. So we have our calendar of upcoming meetings for the year. So the city council has to hold a couple meetings. They're required to hold them on a certain dates. And so there's going to be some date changes, I believe in August. I think we're going to actually remove one of our meetings in August. We'll only have one meeting in August now. And then in November, our meeting will change from the first week, or it'll change from the second Tuesday of the month to the third Tuesday.
Okay.
So I'll get you the official dates next meeting,
Okay.
but just heads up that there are some changes on those dates that are
Okay.
going to occur.
Do we need to adopt that calendar again, or can we just modify the calendar that was already adopted without?
I believe we'd have to adopt it again, but
Okay.
Hiram's nodding yes, so.
Okay. All right, great. Could bring that forward. Anything else? Okay. All right, so the next item we have on the agenda is the approval of the Planning Commission minutes from February 2nd. And Sylvia did tell me she read them and had no changes. I thought I'd pass that on. I need a motion on the minutes.
I'll motion to approve the minutes.
Okay,
For,
is that Troy?
yeah, do I have to give a date? The
Yeah, give the date,
Minutes for
February 2nd.
February 2nd, 2021.
Okay, thanks. So we have a motion. Do we have a second?
I'll second that.
Ethan Allen seconded the motion. All in favor?
Aye.
Anybody opposed? Okay, so the motion passes. And the next thing we have is a motion to adjourn, if anyone would like to adjourn.
That's John's favorite motion.
Come on, John, do it.
All right, let's do it.
Woohoo!
I make a motion that we adjourn this meeting.
John
Second.
made a motion, seconded by Alan McDonald. All in favor?
Aye.
Aye.
Hey, you have to put your hand up on that one, right? Hi. Thanks,
All right.
everyone.
Take care, everybody.
Appreciate all your work. Hiram, thank you for coming. I hope we can have you back for training. It was really helpful. I'd love to continue some training modules.
Yeah, absolutely. Happy to
Okay,
be here.
thank you.
Have a great night.
Bye-bye.
Yeah.